Good evening. This is John Milburn for Laws 12062, Alternative Dispute Resolution. We're into week 7 of Term 2, 2017. This week is an interesting week in terms of content. It's also a scary week. The reason I say it's scary is that there's a lot of options that are presented to you for consideration. Those options, in terms of ADR, need to be considered by you in the context of how you might advise a client that is either in a dispute or going into an arrangement, contractual or otherwise, that may result in a dispute, and how you engage with your client in that dispute process. So from the perspective of you as a lawyer advising a client in ADR, there are those 3 aspects that you need to consider within the context of a range of ADR options that we'll discuss tonight. It's also scary because I want you to consider this from the perspective of you being the ADR practitioner. And as you read the material, as you consider the content of tonight's session, ask yourself, do I see myself as being an ADR practitioner in one or more of these fields that we're talking about? If so, how would I become recognised as an ADR practitioner in this particular field that I'm interested in? What are the compliance issues? Do I need any special training? Do I need any special certification? Will there be any work? And if so, what type of work? Are there any other qualifications in addition to a law degree that I need to consider if I want to become involved in, say, collaborative law practice? So you've got that aspect to consider as well. And finally, it's a bit scary because a topic like this week's is so easy to write. It's so easy for an examiner like me to write a question that intertwines or draws from some of these concepts. So you've got those 3 scary aspects tonight. But I hope it's fun scary, and I'd like you to treat it as fun scary. Okay, so we're dealing with a range of dispute resolution processes. I gave you some homework tonight, so I do hope that you've had an opportunity to do your homework, and I would like this to be a little more of an interactive session than has been the case in the past. So tonight we're dealing with collaborative law or collaborative practice. We're dealing with the issues to do with the dispute resolution advisor, dispute resolution boards, partnering, appraisals, both case appraisal and expert appraisal, evaluations and determinations. We're dealing with court-appointed referees, adjudication, and if we have time, dispute resolution in the criminal justice system. I suspect that last one I'll hold over till next week. So there's a whole wide range of areas that we need to consider. Right, let's start with collaborative law. Where did collaborative law begin? Feel free to unmute your microphone or use the chat facility. You can type a word. Yes, Steve?
I believe it originated in America. Is that correct?
Probably in America.
I must admit, I did research this, and
yes,
apparently it originated in America, and it was primarily to do with family law.
Yes, exactly. And no, you're absolutely right. And I think it was a practitioner in the Chicago area. It was relatively recent. It was a great innovation. It certainly started in the family law field, and that's its main area still today for collaborative law. And you're absolutely right. It was in the United States. All right. So collaborative law commenced overseas, has moved to Australia, started in family law. I've said it continues in family law. So what does it mean? If you were a collaborative law practitioner, what would be your ethos? What would be your MO? Karen says, Stu Webb from Minnesota, 1990. Yes, thank you. Thank you very much for that. All right, so what would be your modus operandi if you were a collaborative law practitioner? Firstly, would you be a lawyer? Would you be an ADR practitioner? How do you see it? a lawyer, says Jamie. That's the way I see it. All right. So what's the, if you like, a definition of collaborative law? I don't know about you, but I always go to NADRAC. It doesn't exist as such anymore, but it's still highly persuasive. So if we consider the NADRAC definition, it says this, where the process is led by lawyers representing each of the participants, where it is agreed that the lawyers will cease to act for their client if the matter proceeds to litigation. So that's collaborative law. What sort of lawyer do you think would like to be involved in collaborative law? One that likes ADR?
John, if I was to take a guess, I would say family, because there's so much other law that intertwines within it.
Did you say family, Pagan?
Yes, yeah.
Family law? Yes, absolutely. I think that it's very good. Another message on the chat facility was one who is good at negotiating, says Jamie. Yes. Sometimes people say one that avoids litigation or doesn't like litigation. Nobody said that tonight. I always disagree with that. I think that a litigator makes a very good collaborative law practitioner. It might sound a bit contradictory that you've got someone who's very talented in litigation doing collaborative law, but if you do collaborative law well, you will frame your argument in such a way as to be persuasive. So you have to be good at negotiating, you have to be good at advocacy, you need to be good at framing your case. So collaborative law, I think, is one of the watch this space areas of practice. I think it will grow. I think it will grow particularly in family law, but I'm waiting for people to develop beyond family law and adopt collaborative law practices elsewhere. Certainly lawyers, for as long as I can recall, have had what we called informal conferencing or roundtable discussions, where the two lawyers and the two clients meet and discuss issues. So that roundtable conferencing has been around for a long time. Collaborative law is a little like that in that there is no mediator, there is no conciliator. It is the two lawyers typically and the two clients in a round table type situation. But where it differs from an informal conference is that it goes beyond that. So there is this commitment to the lawyers to withdraw if the matter goes to litigation, and that commitment is in the form of a collaboration agreement. It's formalised. It also goes beyond a roundtable conference in that it's not designed to be necessarily a one-off meeting where we will meet on this afternoon in an attempt to resolve the matter. The collaboration agreement may provide for a series of meetings. It may provide for a program of disclosure of documentation and an exchange of ideas. So it's more elaborate, it's more formalised. Now, Karen says the Lopic article talked about how it's the future focused towards needs and goals and doesn't look to apportion blame. That's excellent. And that's kind of familiar too, isn't it? So thank you, Karen. That's familiar, isn't it? Because when you think about the aims of a mediator, the mediator is looking to identify the issues rather than the principle of the issue or the position of the parties. The mediator is also looking to divert people to a forward-looking focus. So where you've got good collaborative lawyers involved in a matter, while they fight hard for their clients, they are nevertheless striving to get their clients to look at issues and look at forward processes. Excellent. So that's what collaborative law means. That's where it's grown from, where it started. Tell me about the process. Is there anything about the process that stands out to you? I've sort of given some hints. Unmute or type. And thank you all for joining us tonight. All right.
Well, yes. The bit that struck me
Karen?
was the point you mentioned earlier about how they have the agreement that it's not going to end in litigation, and that if it does break down to go to litigation, then the lawyers are out and they
The
can't
lawyers
have
are out.
that dispute again.
Yep.
So that they really are invested in not going to court.
Exactly. I think it's a wonderful idea in that it really says the lawyers are saying to the clients, we promote ADR, we believe in ADR, this is going to work, we're going to roll up our sleeves and we are in with this with you. And we're not in it if it's not ADR. So I like the philosophy behind it. It really does emphasise the focus on collaboration, on working towards resolving a problem, and from the party's perspective, interest-based negotiation is a key factor. But the collaboration agreement may provide for the introduction of a mediation, and very often does. So it may be that when the lawyers work with their clients in coming to the collaboration agreement, they may structure this program where it involves 2 informal meetings, exchange of documentation. If the matter is not resolved, they build in a mediation process as well. So it has all these places where the matter can resolve, but if it doesn't, there is a next step which is agreed to by the parties. And but generally speaking, there is no third-party neutral. That can be built into the program down the track. So the other factor that I think is important is this, that a good collaboration lawyer is an ADR practitioner, because the collaboration lawyer, collaborative law practitioner, in some ways has to assume the identity of a mediator. They're not mediating, it's not a co-mediation by any means, but we've already identified that some of the factors that a good collaborative law practitioner will consider and emphasise and instill are factors that are used in a mediation sense. All right, so what are the characteristics of collaborative law? Can someone give me some ideas here? It's question number 3 in our homework to do. What are some of the characteristics of collaborative law?
Yeah, John, I'll have a go again. Once again, it's from the research I did, admittedly through Google, and apparently where it originated in America, it's actually got an act. It's got a corporation law act. I'm not so sure that we have one like that here, do we?
No, I'm not aware of an act that specifically deals with collaborative law. We have collaborative law organisations, but not a specific piece of legislation, as far as I'm aware. That would be embarrassing if I'm wrong. If you find something, please let me know. But no, that's good. Thank you, Steve. All right, so one of the things we've talked about in collaborative law is a collaboration agreement. We need this collaborative agreement, and that's signed by whom? The clients and the lawyers. The lawyers become parties to the agreement. And it's in that agreement that they disqualify themselves from litigation representation. And so while that process continues, the commitment is that neither party will commence or continue to proceed in court. What happens if, despite the agreement, one of the parties says, oh, I had enough of this, I'm going to court? What would you do as the other side?
I haven't done the studies for this week or last week because I've been moving, but wouldn't you have to write to the other side saying I can no longer represent because of conflict of interest? Is that what you would do? Yeah.
If your client wants to go to litigation, obviously you would have to withdraw. Otherwise, you'd be in breach of that agreement. I think that there would be real prospects of succeeding in having a stay on that litigation to say that there is a breach of contract between the parties, and by commencing litigation, that party has breached the agreement. And you'll see tonight in some of the decisions, courts uphold these agreements and they want parties to go through the ADR process as they've agreed. So the court may well stop the proceedings and even award costs against the party that initiated proceedings. So remember, in family law, you need the Section 60I certificate before you can issue proceedings in parenting. If you went and just did it anyway, the court will not allow you to proceed. Same thing may well happen here. I'm not sure I've got a case to support that suggestion, but that's the way I think at this stage. All right, so while the proceedings are in the collaborative law stage, then there is no litigation. All parties are committed to cooperation. It's non-adversarial. Can you bring in third parties? I've already mentioned that in collaborative law, you can bring in a mediator, you can build that into the program. Can you bring others in? Can you bring in other professionals? What do you think? Yes, says Jamie, experts. Let's think about a family law context. You're a solicitor, you have to draw a collaboration agreement. What sort of experts do you think you might need to call upon and build that into the collaborative law agreement?
Is that the writer, the family law reporter? Is that the same thing?
Look, it could be a family report writer. It could be a social worker if it's a parenting issue. Thanks, Pajan. What about an accountant? What about the family accountant? If you've got a dispute, financial planners, yeah. If you've got a dispute in relation to money, loan accounts, companies, trusts, superannuation, why not bring in a financial planner or an accountant, build that into the program so that there's some agreement. So often people waste time, they waste money arguing over things that really they should be able to resolve. So if you both agree that the accountant is the person who knows about the finances and you can both trust the accountant, build that into the program so that we're not off racing, getting reports that we don't need to commission. What about a coach? We've talked about conflict coaching. Do you sit with your client and say, look, I'm a lawyer, I'm here to represent you, advocate for you, document for you. I'm not your social worker, I'm not your life coach, but it may be a good thing for both of you to have life coaches, or maybe a coach who supports both parties. Maybe sometimes people come into your office as a lawyer and they just want to talk, they want to vent their spleen, they want to cry, I'm not sure lawyers are necessarily good at that. Maybe we shouldn't be doing that, but maybe we should build into the program the support of a coach who can support the parties through the process, help you as the lawyer, and perhaps even provide some assistance with negotiation. Or, as I mentioned before, a mediator. So, obviously, collaborative law is voluntary. It's where the parties commit to staying away from court, and they also commit to full disclosure, and that's really important. Because very often in family law, we have situations where parties don't want to disclose information. They try to hide information. In collaborative law, it's exactly the opposite. We're trying to encourage them to part with that information. Okay, the process relies on trust. It relies on cooperation between the parties and disclosure of the information voluntarily. It's not subject to court jurisdiction or process, but that's the nature of the idea behind it. All right, question. Yes, Karen.
Sorry, I'm actually thinking you were talking about full disclosure, but is there actually a legal requirement that you've got to talk about all your bank accounts, or is it just I'm doing it voluntarily because I'm participating?
It is the latter, but if you're the lawyer assisting the parties to come to an agreement about a collaboration agreement, I think you would want to encourage the full disclosure, because that's what's going to happen if you go to court anyway. And think about another issue. If you're the lawyer involved in collaborative law, with no court making the decision and no formal orders for disclosure, there is a liability risk here, isn't there? And that is that if you're acting for a party who has limited knowledge of the finances or the company or the superannuation or the trust, and you don't insist on full disclosure, the other party doesn't play by the rules, you may find yourself being challenged for unprofessional conduct for allowing your client to enter into an agreement based on only half the information, not all the information. So I think you've really got to insist on full disclosure for your client and the other side and have that part of the agreement. That way, if there is a problem, at least you can say, well, they were the ones in breach. It wasn't me who forgot to introduce it into the agreement. All right, so what are the steps in collaborative law? What are we trying to achieve and obtain from our clients and tell our clients about in collaborative law? I'll get you started. Number one is you're looking to identify the interests of the parties. You're trying to move the parties away from their positions to get them thinking about their interests. So once you know that it's in both parties' interests to resolve the matter at the minimum cost in the best time and to ensure that the children are not adversely affected, what's the next thing that you need to consider? I think you need to start asking the right questions. What questions need to be answered? Because you're doing that, and that's the second part. The third part is gathering information. And once you've got your clients thinking about their interests, once you've identified the right questions, once you've gathered the information, probably at that stage, you're in a position to go to stage number 4, which is generating choices. And once you've generated those choices, you can, number 5, evaluate the options. Number 6 is negotiate an agreement. And number 7 is come to a closure. So doesn't that sound like mediation? We're identifying the interests, that we're asking questions, we're gathering information. Once we've gathered the information, we're brainstorming, we're generating options, we're negotiating, and then we're coming to an agreement. So that's why collaborative law, it looks a bit like a big mediation without a mediator, is the way I tend to think of it. All right, so it did start in family law, but it can be used in civil disputes. So if you have a client that comes to you in relation to a building dispute, then can you adopt collaborative law principles and create a collaborative law agreement? I think you can. It's another thing for you to think about. And it all depends on this big shift from the adversarial to the cooperative. And you do need 2 lawyers to think the same way. All right, so what do you make of collaborative law? It's the paradigm shift. One important thing is that it does take away the dispute a little bit from the lawyers and gives it back to the clients a bit. And it follows, in some ways, a mediation process. And I think, was it Karen, you referred to that article by Darren Coombs? No, Loppich article. All right, I'll just read from an article by Ardag and Coombs. It's called The Legal Profession Post ADR, From Mediation to Collaborative Law. It's, if you want to find it, it's 2007 18 Australasian Dispute Resolution Journal 205. And I can provide the quote because I think it's a bit hard to find the article from memory, but I'll try and find it and upload it if I haven't already done so. So collaborative law is a process without mediators, seems to have arisen in response to competition from mediators, particularly in the family law area, as to changing legislative demands. The authors question whether it is appropriate, whether it is going to serve a purpose, and it leaves open the suggestion that lawyers are creating a dispute resolution process for themselves to exclude mediation. So there is that counter-argument to say maybe collaborative law is a way that lawyers have designed to retain some degree of control and ownership of disputes and take it away from mediators that are not lawyers. there is that argument. I'm not sure that I subscribe to that argument, though. I think there are real benefits to be had for the parties. Okay, any questions, comments, or further thoughts in relation to collaborative law before we move on to the next topic?
Just got a quick question there, John, in relation to the experts. How far can that stretch? Like, are you able to bring in, for example, particularly when there's children involved, people like, or experts like psychologists and psychiatrists?
Yeah, absolutely. I really see no reason not to exclude that. I think that may well be appropriate. The problem is that the experts really are in a situation where they're going to find it difficult to give evidence potentially down the track, but you could build that into the program to allow them to do so. Particularly, I'm thinking of, say, the family accountant. If there's a dispute that goes to court, eventually you probably want to have them provide information to the court as well. All right, but good question. Thank you, Steve. Okay, well, I'll need to move a bit faster. My fault. Dispute resolution advisors. So where did the dispute resolution advisor concept come from? Where did it start? Oil code? Yeah, look, the answer I guess I'm looking for is construction law disputes. Particularly, there was an example, I think, in the text, a dispute resolution advisor model was developed in Hong Kong. And here's the way it works. And many government departments, particularly in Hong Kong, use this procedure. So the role of the dispute resolution advisor is to advise parties on how to resolve the conflict rather than to determine the conflict. So remember that line on page 3 of Spencer, that one, where I said, okay, look, there are 14, I refer to that all the time. And if you look at that, you'll see that dispute advisors is right up there at number 3, which means that it's one of the more informal, consensual forms of ADR. Not quite as informal as negotiation, but getting there. So dispute resolution advisors really is a means of providing for dispute avoidance rather than dispute resolution in a strict sense. Dispute resolution advisors often are considered at a pre-contract level, usually in construction. And what you're looking to do here is take advantage of people who are advisors with technical or special skills. And their job is to provide like an on-the-spot type resolution to the problem. The encouragement is that the dispute resolution advisor comes in, says, guys, you've got a problem. Let's stop fighting with each other. Let's see if we can work the problem. I'm here as an advisor. I'm not here to give you an answer to the problem, but show me what it is. You know, I'm an expert in this field, blah, blah, blah. All right. Ask some questions. Say, have you been doing this? Have you considered that? And the idea is that the dispute resolution advisor will come in immediately. Everyone owns the problem, and we try and get a quick dispute resolution mechanism in place. And you can understand for a construction contract, particularly a big one, every minute that you're not working is costing a fortune. So it's in the party's interests to think about doing this. Now, the problem is, and you might say, well, this is all very obvious. Sure, if you've got a problem, you just bring in an outsider and try to resolve it. But here's the problem. You see, when the parties are at that stage and they are in dispute and it's substantial, we're not talking about little things, we're talking about big problems within the context of a major project, they're not talking too well. They're not necessarily seeing it from the other's perspective. And if you then said, well, we've got to bring in Joe Bloggs or Mary Smith to come in and help resolve this dispute, then they'll start arguing about who to bring in. So the idea is that at the pre-contract level, you build in this mechanism. You say, here is the appointed dispute resolution advisor, or this firm will be the dispute resolution advisor. So it's very important if you're advising clients that you think about these options. And it's essentially a dispute avoidance process. The parties think about issues at a very early stage, and what the advisor will do is try to identify points of agreement, points of disagreement, and try and cut it off before it becomes a full-blown dispute. And very easily these things can become a full-blown dispute. What happens is there's a dispute, they go off to see their lawyers. One of the lawyers says, we're going to get an injunction, we're going to get an urgent declaration, and before you know it, they're in court. The other side is in court, and the divide begins. So that's where dispute resolution advisors who are technical experts, experienced in the area of managing these disputes, can come in and deal with the problem. The key to dispute resolution advisor is to avoid the parties saying, no, that's your problem. No, that's your problem. And start getting them to say, okay, this is our problem. The bigger picture is we've got to get this contract done. How can we work with each other? What can we do? It's all very good in theory, but I think it's worth a shot. So, tip about dispute resolution advisors. Given that the appointment of a dispute resolution advisor is intended to be a dispute avoidance process, the dispute resolution advisor may be agreed upon by the parties at the pre-contract stage. And the dispute resolution advisor can help the parties negotiate the contract for the project, or may be appointed by the parties via the contract. So the dispute resolution advisor can be actually named in the contract, or better still, you get the dispute resolution advisor to come in to help the parties at the pre-contract stage, so that you're really getting them involved at an early stage. All right, so these are the things that you need to consider. Spencer at page 151 provides a flow chart. So look at figure 5.1 in your text. You'll see the dispute resolution advisor flowchart. Now this one is just an example. It's one that was used for the refurbishment of the Queen Mary Hospital in Hong Kong. That's kind of where it started. But think about that type of process for the dispute or the parties that you're involved in advising before they go into a contract, and think about whether that type of program would help your clients. Now, it might be a commercial dispute, it might be something completely different. So that's the role of the advisor is not that of an appraiser, not that of a referee. We'll talk about that later. What they're trying to do is not impose a solution, but get the parties to work with each other. Look, I am running short on time. Almost certainly we're going to have to flow into next week, but I do want to show you something as a worked example, and this is the NBN Special Access Undertaking. I'll just call it up on my screen, and I'll share the screen and hopefully do so now. So this is through the ACCC. I've got three screens and I'm trying to work out which is which. What screen have you got? What can you see now? Can you see my son diving into the ocean, or can you see NBN? Or can you see nothing? What is it?
Yeah. ACCC website, NBN Co.
Ah, very good. All right, thank you. So that's the NBN Co Special Access Undertaking. That's, if you want to have a look at how this works in practice, that provides for the dispute resolution agreements. And you'll see over here on the left-hand side, the dispute resolution advisors are established as part of this program. So that's for regulated infrastructure. And if we just look at the dispute resolution agreements, you'll see there the approval of resolution advisors and the terms of the appointment, all done at pre-contract stage with respect to the NBN rollout. Done through the ACCC, and here we have a pool of the people who are appointed as the pool members for the advising process. It also goes on to provide for those practitioners' appointment, remuneration, etc., and the terms of their appointment. It also provides for their guidelines. So you see down here the approved dispute guidelines. If you look at that, the document contains the dispute guidelines prepared by NBN Co for the purpose of what's called Clause 6 of the Special Access Undertaking, and that is given pursuant to the Competition and Consumer Act, Commonwealth. Now, I'll give you a tip. Have a look at this document, have a look at the website, because it provides some very useful precedents. And if you want a precedent on how to draw up a dispute guideline agreement for dispute resolution advisor, well, there's a very good example. And as always, when you're using precedents, make sure that you don't slavishly reproduce the material. For one thing, that's a breach of copyright. But secondly, you've got to always give independent thought when you're dealing with a precedent. I'll just stop the share now. All right, any questions about dispute resolution advisors? I didn't make that as interactive as I'd like, sorry. Any questions, comments? Can you see yourself being a dispute resolution advisor, or can you see yourself being an advisor to a party going into something that might be useful? Government funded, yes, Jamie, yep. Well, it's sort of like and each situation is its own situation. So NBN, they would be government funded, I'm sure, but otherwise it can be private. Okay, let's go on to dispute resolution board. First thing I do, where does it fit on the sliding scale? Number 4, which means that it's quite consensual, it's quite informal. So what is a dispute review board? Any ideas? Where did the concept of a dispute review board emanate from? What does a dispute review board do? Is what they do binding and final? And do we use them much in Australia? That was the homework. Let's have a look at it. Okay, let me give you an overview of dispute resolution boards first. So a dispute resolution board is an example of a dispute avoidance process. Not surprising, it's not dispute resolution, it's dispute avoidance, and it provides for an opportunity to resolve matters quickly. They're, again, typically in the construction industry, and the idea is, look, it's a very simple idea. The idea is to keep the lines of communication open so that there's less potential for problems that may lead to a disruption. So a dispute resolution board is essentially a panel of experts. Now, they meet regularly throughout the course of the project, and they involve themselves in disputes at an early stage. And usually there are 3 appointed to help with deadlocks. So it's a little bit like the dispute resolution advisor, but now we're talking about a panel of 3. And there's 3 because you may have a 2-1 to help with the deadlocks. So while it's not binding and legally binding, it's one step up from dispute resolution advisor in that they're there more than just to advise the parties in a general sense. They're really there to try and help. So usually these disputes are quite technical, and having a lawyer as part of a team in the dispute resolution board would assist, I think, particularly to breach any deadlocks. So have a look at a website called the Dispute Resolution Board Foundation. I'll give you the, I won't call it up at the moment, but it's http://www.drbf.org.au. Now, that board was founded as part of a global not-for-profit organisation. The idea is that it's dedicated to promoting avoidance and resolution of disputes at an early stage. And of course, as you might expect, I can't help myself, I will show you the website. I know I'm battling time, but there's the website, the DRBF, and have a look at that because it provides information about the process, the parties, and you'll find in there that you can become a member of that board. The DR Dispute Resolution Board concept has developed to become recognised in many different commercial contracts and elements. And if you want to be a member of that board, you can apply, and there's a list of people. All right, so what do we draw from that? What tip can I give you in relation to dispute resolution boards? I think it's this. At a pre-contract stage, the parties should consider how the process is going to operate in practice. For example, are there disclosure obligations? Are the parties going to be able to cross-examine each other or have someone come in to cross-examine in front of the dispute resolution board? A lawyer is going to be involved in the process of making submissions to the board, preparing documentation, etc. So it's all very well. What I'm really saying is this. Here's the tip. If you think about a dispute resolution board at the pre-contract level, that's great. If you implement it, that's great. But give it some structure. Make it clear to the dispute resolution board through the agreement, this is what we expect you to do. Here's how we anticipate you will go about your process, and here's how parties can engage with you. I need to keep moving. Partnering. Number 2 on the list, right up the top, second to negotiation. Partnering is a dispute avoidance process. It's less formal than dispute resolution boards. Partnering, I could say it's like a DIY dispute avoidance process or ADR process. That's what partnering is. It's a bit do it yourself. So the procedures are firmly aimed more at avoidance than resolution of a dispute. Again, it's pre-contract. And once again, you're taking advantage of people with technical skills. One thing about partnering is this. The parties don't necessarily have a formal agreement, but they do have a charter. And I could probably describe partnering as a sophisticated handshake. And it's where there's in the charter, I mean, it might seem a bit silly, but you develop this charter in partnering where the parties commit to certain things. The idea is that you build a common culture, and that common culture in partnering is all about mutual trust. So you're saying it's a commitment. Here is our charter. We will trust each other. We will disclose information. We will talk to each other if we have problems. We will not allow things to develop to become a real problem. So there are 2 parts, I guess, to partnering specifically. The first is you have a workshop. You actually have a workshop and you build this into the agreement. We're going to be partners, we're going to have a workshop. And the second thing is we will develop a charter. So what do you do in the workshop? Again, you have an agenda, you find a location, you find a facilitator, you go through some team building exercises, you identify what the interests of the parties are, and the coach, through the partnering, what you're trying to say is we are a team. We're now going into a project. We're like a football team. The enemy is the project. That's our enemy, not each other. So you go through this workshop project, and once you've got the workshop, you then develop the charter and say, okay, now that we go into this project, here's our mission statement. Here are the ground rules for communication. Here's the review process. So it's like a football sort of situation is the way I think of partnering. You can use it any industry you like. Typically construction, I guess, is where it might be of value, but it can work beyond construction. It can be used in anything. It's probably useful where there's a degree of complexity in the relationships. If you anticipate that there is a risk of breakdown, multiple parties, different languages, different cultures, whatever it might be, then you might suggest as a lawyer partnering. They might seem a bit silly. You might get eyebrows from the other side or even your client. But if it's done well, I think it's good. So think about the philosophy of partnering and ask yourself, can we convert the them and us into a collective we? And can we emphasize that what we want is to deal with that project over there, and we all want to profit from that, live happy, healthy, safe lives, and work on to the next project rather than fight with each other. So it's sort of that team building type thing. And what you're emphasizing in partnering is mutual respect, flexibility, open, honest, transparent actions. It's all very, is this all sounding all very nice and non-lawyery? I think it works, but it'll only work if you sell it. If you're the lawyer and you say, I think we need to have a good look at this, maybe work through some obstacles, at the end of the day, your clients may be very appreciative of the work that you do. I'm going to make a little dash. I've got 10 minutes left. So much for the interaction tonight. Before I go on, has anyone been itching to tell me anything? No? We've got, I think, yeah, we'll move on. All right. So let's do 3 at once. Look on your chart, and together we will deal with what are the 9th, the 10th and the 11th, which is expert appraisal, expert determination, and early neutral evaluation. Okay, appraisal. Appraisal is in 2 types. You have case appraisal and you have expert appraisal. Now, and I'm putting all these together because they're all quite similar, and you'll find this part gets really confusing because the terms just, you know how I was saying sometimes mediation looks like conciliation and vice versa because people do use different terms. Well, it's even worse when you're dealing with these areas. So what is described as case appraisal in the legislation often looks like neutral evaluation. Anyway, what are they? So they're very similar. They are down the line. They're closer to 14 on that list of 1 to 14. So they are more adjudicatory rather than consensual processes. The terms are used interchangeably often. They're not uniformly used, these terms. So it does get confusing. Some of them have statutory force through legislation and through rules such as the UCPR. We know what UCPR is, don't we? Uniform Civil Procedure Rules. Okay. So let's look at case or expert appraisals. So this is an alternative dispute resolution process. It's not a dispute avoidance process. You see that basic distinction we're talking about tonight? DAPs, dispute avoidance processes, as opposed to sort of ADR in the more traditional sense. This is ADR in the more traditional sense. So generally, the decision of a case appraiser or expert appraiser is not binding, but in the case of court-ordered case appraisal, it can be, or it may be conditionally binding. It's whatever we're talking about here, if we're talking about appraisal or determination or evaluation, it's usually an expert in the industry that takes the takes the role of being the ADR practitioner. Now, case or expert appraisal is relatively informal, but it does involve presenting arguments in a case. But there are no rules of natural justice. There's no reason, there's no need for a written decision as such. And the appraiser suggests a desirable outcome, and generally speaking, the parties are free to accept it or reject it. So of the ones that we're talking about right now, appraisal, determination, evaluation, appraisal is generally the most consensual. It's the least formal. Expert determination is often binding, very similar to case appraisal in that it's undertaken by an industry expert. It's again relatively informal, and there's no need for a written decision, but the decision remains private. Early neutral evaluation is ADR. It's usually undertaken by a lawyer and similar rules. So in early neutral evaluation, the practitioner makes a determination on key issues in dispute and the most effective means for resolving the dispute without necessarily determining the facts. That's what NADRAC says about evaluation. So the tasks that I gave you for homework were to consider the operations of appraisers, expert determinations and evaluations. When are they binding? When are they not binding? And what is the difference between them? And I think it's close enough now to 8 o'clock that I can leave us in suspense and say we should do that next week. Are we okay with doing that? Otherwise, it's too big a project and I'm just going to rush like crazy to get through it. But I will give you some extra homework to do. I would like you to look at the Civil Proceedings Act of 2011 in Queensland, particularly around section 46. I'd like you to look at in fact, the whole section about case appraisal in the Civil Proceedings Act. So I'd start, I think it's section 41, you should start around there, and there's about 5 or 6 sections. So that's not too hard homework. I'd also like you to look at the UCPR. There's specific rules about case appraisal, rules 334 through to 345. And have a look at those in the context of case appraisals, evaluation and expert determinations generally. And that should do us for tonight. All right, any questions before we leave about the assignment or what we've covered tonight? All good?
I have a question about the assignment, John. Is it 15 minutes recording or 25 minutes recording?
It's a while since I wrote the assessment. I could look it up. I thought it was 15 minutes.
Oh, all right. Yeah.
Does anyone else have a thought on that?
I think there's a maximum of 25.
Okay.
We did our recordings the other day and we're anywhere between 17, 20 and 24 and a half minutes between the three of us.
Right, each one. So I thought it was 15, but I must have said up to 25. Yep. I'm usually fairly flexible in that. So thank you, Karen. I hope that helps.
Yep, thank you.
Thank you. All right. Any other questions? Great. All the best. We'll see you next week. Bye then.